A very good evening, viewers, and welcome to our live program on Legal Hints, in which we'll be discussing today about the legal aid and the judicial contribution in Meghalaya. We have with us our esteemed panelist, Shri N.A. Khan, who is the District and Session Judge of East Khasi Hills and is also a Member Secretary of Meghalaya State Legal Service Authority. And we also have with us Shmriti D. Sautun, who is also a Secretary of District Legal Service Authorities. Welcome, sir and ma'am, to our program. As we go ahead with the program, sir, I would like to ask you first, what do you understand and how as a person would understand what public litigation, interest litigation is and how it originated?
You see, the very terminology, public interest litigation, itself speaks about, it deals with something, it deals with public, and the interest of the public has to be there, and this is a litigation which involves public at large. Now, to put it, to define it precisely, I think we cannot have a straitjacket formula for defining public interest litigations. We can just say that the public interest litigation may be taken as a means of legal action initiated in the court of law for enforcement of the public interest or general interest in which the public or the class of the community has pecuniary interest or have some interest because it would affect their legal rights or liability. Now, I will also like to refer how the court looks at the public interest litigation in People's Union versus Union of India, 1982, volume 3 SEC 235. The Honorable Supreme Court has observed that public interest litigation is a strategic arm of the legal aid movement which is intended to bring justice within the reach of the poor masses, which constitutes the low visibility area of humanity.
So as per, for a lay person, for us to understand, how would you define its significance for a lay person?
A public interest litigation is of a great significance in the sense that it had evolved. Keeping in mind the concept of the directive principle of state policy. You see, Article 39A of the Constitution provides that everybody should have an access to justice. Now, there are certain section of people who are economically disadvantaged or socially disadvantaged. Now, their economic and social disadvantage should not deprive them of a level ground in the field of litigation or for having access to justice. Putting it in a very simple word, poor people who do not have means to enforce their rights, they should not be deprived of their right to enforce and protect their right. Now, when you find large section of people, if they are affected and they don't have means to approach the court, now these sections of people or the community, their cause can be espoused by anybody.
That's very encouraging, and it also makes us realize that yes, as a lay person, and like how you have rightly put, that people who cannot afford, there is a means, there is something which is very encouraging for us that we can approach. We know that, and it is very helpful. Thank you, sir, so much. And now I would like to question ma'am. Ma'am, from time to time, and we have always heard, like how you said, that legal aid services, we have seen in newspapers, they are conducting awareness programs. So my question to you, ma'am, would be, what is legal aid services all about, and what would be the exact means and focus of having a legal aid?
See, legal services, under the Legal Services Authority Act, what we intend to do is to provide legal services to the poor, the needy, who cannot afford to have access to the the legal infrastructure that we have right now. As you know, if there's a litigation, you'll have to engage a lawyer if you have a litigation, but many of them may not have the means to engage a lawyer. So through the Legal Services Authority, we give free legal aid, legal aid through legal aid councils to these people who have any issues that they need to get redressed from the Court of Law. So when we say free legal services through the Legal Services Authority, we talk about free legal service, where you don't have even to pay a single rupee for the legal counsel that you get through a legal aid council.
Okay. So having said that, ma'am, so who can seek? Like, a lot of people are not aware.
Yeah.
One thing is that, like when you said that people cannot have a legal access, you know, or they are unaware that, yes, like how sir has said, that whenever we go to court, people who can't afford, they think that's a huge sum of money for the litigation, A, and B, also the lawyer's fee. So where and how can people seek legal aid?
See, the Legal Services Authority Act under Section 12 have clearly laid down who are the people who are entitled to free legal services. A number of persons who are entitled has been enumerated under the section, which includes women, children under the age of 19, any person who's differently abled, industrial workers, victims of trafficking, or any person whose income is less than 3 lakh rupees, a scheduled tribe. When we say any person, we find many people who are in the jail, under trial prisoners. We find people who are being arrested. So the Legal Services Authority extend its services of providing free legal aids to these people, right from the time of arrest, when it comes to a person, till the time where his trial goes in the court. So these are some of the free legal services that we provide through a legal aid council.
Okay, thank you so much. But ma'am, like how you said that for the under trial prisoners, so are they made aware that how do they get aware that they can access to legal aid? Because if I am to put in a very simple word, I could be an under trial prisoner, I might be arrested. Then how do I know?
See,
or how do I become aware that I can seek legal redress, which will be free of cost?
See, at the moment when the person is arrested, within 24 hours, he is required to be produced before the nearest magistrate. So when he is produced before the nearest magistrate, it becomes a mandate for the magistrate to find out if the accused can engage a lawyer or not. If he cannot engage a lawyer, it is the duty of the magistrate to inform this person who is brought before the court that, see, there is something called free legal services, where we will give you a legal aid counsel free of cost to represent you in the court of law. So once he says that, I cannot engage a private counsel and I need free legal service, so he just fills a form which is there in the court, and then he sends it to the Legal Services Authority of the respective district, and then we appoint a legal aid counsel for that person.
Thank you so much. It's very informative, because there are a lot of people out there, I'm sure they must be wondering that, okay, we know now, but how do we go about it? How do we approach, or who will help us with that? Thank you so much for telling us even regarding the form that they have to fill the forms, which is very informative.
And just to add, just to interrupt and add, this form is available online in the website of Meghalaya State Legal Services Authority. So once you go there, you'll find a form you can just download from the website of Meghalaya State Legal Services Authority.
So suppose if someone is approaching, so they can directly download that and fill in the criteria, if so be it, and then they can forward with it.
Or they can come to the front office of District Legal Services Authority.
Thank you so much. That was very informative. Coming to sir now, we have heard so much about fundamental rights, especially in today's world. Every point of news we see, people are talking about, yes, this is our right, this is our right. No one talks much about duties, unfortunately. Having said that, sir, how would you briefly highlight the importance of fundamental rights, and more so also our duties?
You see, I understand that when we are talking about some legal matters, sometimes, you see, we keep on always talking about right, duties. Something which is fundamental also needs to be understood. When we talk about rights, because right and duties are part of the same coin. There cannot be any rights without duties. And to put, first we have to understand when we talk about fundamental rights and duties. Now when we talk about the fundamental rights, you just imagine that on one hand there is a government, state, they have got everything at their disposals, the police, the army, the force, and they can do anything they want. And as a citizen, what do you have against the mighty state? You are, as a citizen against the mighty state, what do you have? They can run over you, they can do anything they like. Now let me go back to the preamble of the Constitution. You see, the Constitution is not that it was imposed on us. We, the people of India, we have adopted the Constitution. When we adopted the Constitution, we have chosen to have this kind of a government. And the government has also made a promise in the Constitution that, look here, you elect us to rule. But these are the promises we make, that your fundamental right in the part 3 of the Constitution will be protected by us at any cost. I can give you one example. During emergency, the fundamental rights were suspended. Right to move to the court was suspended. The court intervened. Well, there was some dissenting, the dissenting judgment became a law later on. They said that whatever may be the situation, a person cannot live a human life without fundamental right. So these are the rights against the mighty state. Now, fundamental right is akin to human rights. And these rights are not conferred upon us by law. These rights are inalienable rights. We are born with these rights. What the law does is, the law only recognizes. So if you subtract the fundamental right, I think it will be a total anarchy. And these are the rights against the mighty state. That is why you find, whenever there is a violation of the fundamental right, moving to the court for the protection and enforcement of the fundamental right itself is a fundamental right in Article 32 of the Constitution of India. So the fundamental right is the basic right of a citizen. Now coming back to the fundamental duties, now you find fundamental duties, you find in part 4 of the Constitution, Article 51A. It has enumerated list of duties, and the very idea of duties, duties is a responsibility of a citizen. Once we perform our duty, we will have a situation where everything is very peaceful. The question of protecting the rights will not come. Duties goes side by side with the rights. If you don't perform your duty, that is where we have to chase for our rights.
Right. I think very aptly said that yes, it is a two side of a coin, and it's very important. As when we think of like how you have very aptly said that rights are there, and it is to prevent us as citizens from total anarchy, so is our duty. And if we as citizens take up our duties very seriously, of course it's not going to be an utopian world, but at least we can aim for it. And like you have said, yes, it will be much easier for law and order situation also to take place. Thank you so much for that. Now we would like to ask Sir first that this alternate dispute redressal, we have talked about court redressal, but we would like to know more about alternate dispute redressal. What is it all about, the term ADR, and what as a layperson can take away from alternate dispute redressal? So first you.
Now I begin with that. When you talk about alternative dispute resolution, I just like to quote Abraham Lincoln. He says that discourage litigation, persuade your neighbors to compromise whenever you can, point out to them nominal winners is often a loser in terms of fees, expenses, waste of time. ADR, alternative dispute resolution, is a holistic concept of a consensus oriented approach to deal with potential actual disputes. To put it in a very simple word, is a method of, with consent resolving a dispute which has a potential of becoming a litigation. In ADR method, the advantages of the ADR method is that when we try to resolve dispute through the alternative mode, there is not much of law. Lawyers are not involved. More common sense is involved and goodwill. And the very aim is to arrive at a workable consensual solution to the dispute in a flexible manner. The emphasis is win-win settlement rather than win-lose situation of a party. You see, in a traditional litigation, a court adjudicates. There are conflicting interests of the parties, and these interests are adjudicated, and there is a decision of the court. When there is a decision, there is an aggrieved party. One will be winner and other will be a loser. The advantage of the alternative dispute resolution is this, is a win-win situation where the party resolves the matter amicably. Nobody is a winner or a loser, but then you see that the party, it brings finality to the dispute. The party, after the resolution, lives peacefully. The hostility is not there, and it brings to an end to a litigation with the least expenses and in a very less time. Now you find that, as you all know, that the courts are really overburdened by under tremendous stress of litigations and the cases pending. Now you find that under section 89 of the Code of Civil Procedure, it provides the alternate mode of resolving the disputes. One is arbitration, second is conciliation, third is mediation, then we have settlement out of the court through other judicial means, what we talk about Lok Adalat. All these settlements are alternative mode of settlements outside the court. And let me tell you that this section 89, the legality of the section 89 was questioned before the Honorable Supreme Court, that this section does not pass the test of law. This was a challenge in Salam Bar's case. The Honorable Supreme Court found a lot of flaws in this section 89, but did not interfere on the legality of the section 89 of the Code of Civil Procedure, only for one reason. The intention of the section 89 is to bring resolution of a dispute outside the court, and that is the need of the day, because all you know that because this alternative dispute resolution, it deals with civil cases. A lot of time is taken for adjudicating a civil disputes. So this is quick, saves money, time, and it brings finality to a dispute.
Thank you so much, sir. For ma'am, I would like to also like her to elaborate on that. Sir has said that yes, one note which we can take about is that ADR is only meant for civil cases, because for a lay person, when we talk about alternate dispute redressal, the first thing comes that okay, all kind of cases. Sir has specifically said, and which is rightly so, thank you so much, sir, for pointing out that ADR is only used for civil cases. Sir has already said the different kinds of ADRs. That means the different kind of resolutions we can seek for arbitration and all. Coming from a layman's point of view, if a person or a corporate needs to undergo for expediting the cases when it comes to ADR, as a person who's been adjudicating, what would you suggest and what would be your inputs, ma'am?
See, as Sir said that in section 89 of the Civil Procedure Code, they have laid down as to what are those methods of resolving the disputes, that is arbitration, conciliation, mediation, a judicial settlement through Lok Adalats. So these are the means where you can opt. So as Sir said, just to add to what Sir said, in an alternate dispute resolution, the parties mutually cooperate to settle their dispute not through a court proceedings, but through a discussion with the help of one third party who is a neutral party, who has no interest in the case, and who will help them come out with a best possible solution. So say in arbitration, what happens is, in arbitration we have the Arbitration and Conciliation Act, where you appoint an arbitrator. So both the parties have to appoint one arbitrator each, and then thereafter these two parties agree on another one arbitrator, because in an arbitration it has to always be an odd number of arbitrators. It can never be an even number. It has been laid down in the Act. So what happens in an arbitration is that the parties agree to bind themselves to the decision of the arbitrator. So that is arbitration. However, in a conciliation proceeding, a party can make a proposal for that we go and settle this matter outside of the court through a discussion, a negotiation. So if the other party accepts, then a conciliator is appointed. So this conciliator does not give a decision in a conciliation, but what he do is that he tries to bring out the what is the conflict between the actual conflict between the parties. He tries to generate an option for solution, taking into consideration the legal interests of the parties, taking into consideration the emotional, the personal, the business relation between the two people. So now then it's up to the two parties to decide which option to select. So it's not that he decides for them, it's just he gives an option, but it's up to the party to come out with a solution to their issue. Then we have mediation. Mediation we've used a lot when it comes to especially matrimonial disputes. In the mediation, what happens is that the two parties, the disputing parties, come in a mediation table where one mediator, who is a trained person, he conducts the mediation. Unlike in a conciliation where he at least generates an option of solution, in a mediation it is the parties themselves who comes out with a solution. So he is just like an umpire. He sits and he helps in finding out, sometimes what happens, especially we've seen in matrimonial matters, when we help, when we help in the mediation process, that because of the conflict and the strain in the relationship, they forget what is the actual problem. So then, sometimes the litigation goes on for years and years. There is a divorce petition, there's a maintenance petition, there's a DV Act. So these are the kind of thing in one, they fail to identify the actual issue that is there between two parties. So in a mediation process, because the mediator is a trained person, he helps these people to identify the conflict, ease the tension between the parties, and then talk to these parties, help these parties have a conversation with each other to come up with a solution. So in the mediation, the parties come up with a solution to their issues. Then we have judicial settlement, as I said, through Lok Adalats. So the courts can, if there is a matter where there's a dispute between any two people regarding a property or anything, and they feel that there are elements where these parties can settle the matter without going through the process of litigation, then they can refer the matter to the Lok Adalat, and the Lok Adalat can take up the matter. So in a Lok Adalat, whatever decision, so the parties, they come, they negotiate the terms, they compromise there, or what they what settlement they want from the case. These settlement that comes out in Lok Adalat is binding on the parties, and they cannot file an appeal against those settlement. Whereas in an arbitration, they can challenge the arbitral award. So that is some of the differences, between mediation, Lok Adalat, and
Thank you so much. It is very informative. Coming to what you have said, the difference, I would like to pose you. Say, when you talked about mediation, as in giving an example, which is very helpful for laypersons, because I'm sure our viewers will be, all open ears, and it will help a lot. When you talked about marital dispute, how does a person undergoing marital dispute knows or can approach for mediation?
see, either the matter can be referred by the court themselves, or the parties can make an application, like, let the matter be referred for mediation. Because in mediation, it is the parties who voluntarily submit themselves to the mediation process. Until and unless the party agree for alternate dispute resolution, you can't force it upon them. So that is one thing about mediation. So, and unlike in a court proceeding where things are happening in the open court, and people, there are other lawyers who are coming there, in the mediation proceeding, all the proceedings that are conducted through ADR, most of them are very confidential. Say, suppose in a mediation, I am conducting a mediation of a matter where there are two parties. So if you are sharing something with me, and if you do not give me the consent to share with the other party, I can't even share with the other party. So there is a certain level of confidentiality that is maintained in mediation. So that is why people, when it comes to especially these matrimonial dispute, should opt more for mediation, because it's better than going through the long process of litigation where you will be spending a lot of money in the first place, a lot of time, the emotional strain that it causes upon you. So in a mediation process, at least, this, after you resolve the matter, you resolve in such a way where it reduces the pressure on you. It preserves the emotional, the relationship between the people, the business relationship, the personal relationship between the parties.
I think it's very, very helpful. Like, that is why I think as people who are today watching you, they'll take it back that, as someone who wants to appeal for or wants to go ahead, because like what you have rightly said, and sir has also said, the emotional toll and the time, especially time consuming. And as we all know, unfortunately with the court, it keeps on going, and it's an ongoing process, and changes of dates. So this is kind of not only expedites, but it helps a lot. But having said that, a person who is wanting for mediation has to go through the district, the legal service authorities, or directly approach the court, so that the court will forward the case.
See, in alternate dispute resolution, we have the Meghalaya State Legal Services Authority, we have the District Legal Service Authority, because it's not only matters that which are pending in the court that can be referred for any of the modes of ADR. So even matters that are in a way like about to be, or litigation is about to happen because of this issue. Right. You can refer those matters also. Okay.
I think that's something very informative, because so we know that we don't have to go through court, and the court doesn't have to then forward it for Lok Adalat, or say we can directly approach. So we can directly approach district legal service authorities or Meghalaya legal state. I think that is something very, very important that people know. So if any issues, they can directly approach you.
Because, for example, just to add, in Lok Adalats, we have pre-litigation matters of, these bank matters, where it's about to become a litigation, where the people have been defaulting in payment of their dues to the bank, the loan dues. So those matters are referred to Lok Adalat. So that's one of the mode of ADR. So it's not become a litigation, but, it's come to the ADR, to the Lok Adalat through this, where they refer the matter to us when it's still pending to be filed before the court.
Right.
Just adding to what I'm saying.
Yes.
Because there might be something in people's mind, the people who are there, that when we go for mediation, so the negotiation during mediation, people may withhold themselves. You see, if I'm going to tell these things, or suppose if it's a dispute between a financial transaction. So during the discussions, whatever is discussed or whatever is brought in these conciliations and mediation, those things are very confidential and it cannot be used against them. Suppose somebody says that, look here, I have taken the money, but I want to settle the money. I have taken money from you, I admit, but he may not do so in the court, because if he does so, there will be a judgment against him on admission. So he says that, look, I have taken the money, but then I don't have the money. But then if we can negotiate it, that I'm going to, if you forfeit the interest or something, work out of that. But he admits. But his admission in the conciliation and mediation cannot be used against him if settlement is not arrived. If settlement is not arrived, they did not succeed in arriving at settlement. The parties who have initiated this mediation or conciliation proceedings need not to fear that, look here, I have made an admission, and then in the conciliation proceeding, if the matter is reverted back to the court, I am in trouble because I have already said that. So these things are very confidential and it cannot be used against them in the court. It starts all over again. Nobody knows anything what happened, what transpired in the conciliation mediation. And one example I will give you, this is an example from the American mediations, like how exactly mediation work and what is the benefit. I can give one example. Suppose somebody has got a dispute, two persons are fighting over an orange. One says that it belongs to me and the other says that it belongs to me. The matter has to be adjudicated and the court has to decide. In a traditional adjudication, the court has to decide it belongs to him or him. But once the matter goes to the mediation or conciliations, there is a discussion. And during discussion, it is found that one needs the skin, other needs the pulp. So during this conciliation proceeding, they said, what is the problem? Your requirement is the pulp. No? He doesn't require the pulp and you require the skin. So he takes the skin and he takes the pulp. The matter is settled.
I think that's a very way of, very simple and I think very pragmatic way you have put it out, and I think our viewers will take that understand. So, what we can and I can access personally is that when you talk about mediation or ADRs, the crux of the thing is that where it is important. It's not just like having a lot of other issues being bundled up, and the other thing which they can take is that it is confidential, like how you have rightly pointed out, sir, that people are very confused or they are scared. Most importantly, they are scared. So I think this is a very good thing which you have pointed out, that yes, it is all confidential. Ma'am and sir has pointed that out very rightly, and I'm sure our viewers will be happy to know that, and we'll see more of ADRs happening than our regular process of litigation. And also I think how you have put in that the value, what is more important to take with us in a negotiation rather, not a simple word to say it's a negotiation which is happening. What is more important and what I need and the other person who has filed or is undergoing that the other party also needs. So that is one very good example, sir. Coming to the other part of ADR, and as someone who's been heading issues, cases like that, what would be, what message would you like to give to viewers? And when you say about as an ADR source, you have said, so obviously this is something you would tell people to mitigate more on and approach. So just some few words regarding this, and then I'll go off to another question.
Well, so far as ADR is something which is very new. New in this country. It has just been included in the curriculum of the legal studies very recently by the Bar Council of India. I believe that programs like this will let people know about what is ADR, and through this method we can resolve the matter. As I said that sometimes, especially what ma'am has said, that matrimonial matters, some other disputes, people are very shy to discuss and talk about it, because there might be a lot of reasons, social reasons, various reasons. But the moment we assure them that, look here, very sacredly we can discuss and we can resolve the matter without anybody knowing about it, the only thing they will know is that we have resolved the matter. I believe that people who has cases in the court, they understand better that cases which can be settled, if these cases initiative is taken, at least I say at this stage, make an effort, as I said, why I did emphasize that it will not be disclosed or it will not affect your case. Please make an effort. I say this because recently we had a national Lok Adalat. There was not a quite good response from people because these are the very easy way of settling the matter. But I don't understand that how do you explain this irony. One hand they keep on grumbling about, the cases are not moving, matters are stuck in the court. But here is it, an out of court settlement options are there. Not necessarily that all cases which goes for mediation and conciliation and Lok Adalat will be settled. But what is the harm in trying? That is the message I will say, that all those people who are having a litigation, civil disputes, please work out. Please work out. It is just like if a matrimonial matter is pending in the court and it takes 20 years or 20 years or good number of years for the decision to come, then the couple will say that we were married, by the time we got divorced, we are too old now to live a life. We have the only thing when they look back, they'll see that what we have done is that we were married, the only thing we did was we led our married life fighting in the court. We could have lived together. So somebody needs to intervene and tell them, look here, life is short, these are valuable times, these are valuable resources, you have an option to cut it short and live peacefully. So exercise it, then we can see.
I think, ma'am, your view.
So just to add to what Sir has rightly put, just don't have any fear when it comes to ADR, because it does not mean that once you refer a matter for opting any mode of ADR that you're bound by it. You can always walk out of it if you find that there is no solution that's going to come out of this process. So you can always come out of it. And I think if we opt more on these modes of ADR, then we will be reducing a lot of litigations in the court, because there are so many matters that comes to the court which we, when we preside in the court, we feel that if these parties could have just talked to each other, just listened to each other, they would have come with a solution to their issue without even coming to the court. Because we found many instances where the people, after they've come to the court, after we've explained to them, certain issues that they're having with this case, we point out, see, in your matter, this is the issue that you're having. They resolve the matter then and there. So if you can do that, before you opt coming to the court, let's make it a last option. Find a mode, another way of settling your matter through ADR, and that is one of the best way, because you find a best possible solution to your conflict. So one should always strive for that, I think.
I think you very rightly said, and this brings to me another next question which I would like to ask you individually, because being from Meghalaya State Legal Service Authorities and District, you all have we've heard so much, like I said again, and I would love to listen, and as viewers also, I'm sure, the challenges which you all are facing when it comes to awareness and making, like what you said last time when we did Lok Adalat, the response, because of lack of understanding perhaps, or the confusion. So my question would be, when it comes to service authorities, the one part is the awareness part. Do you feel what necessity and your thoughts and your challenges? And also we would like each of you to share the success stories also, because this, I think, motivates people and encourages today who are listening to you and seeing you will be motivated to say, okay, there has been success rates, and this will help, like you said, ADR becoming, the most upcoming, redressal forum. So I think this will encourage a lot of viewers to come forward listening to you about your success story. So, sir, I'll go with you first.
Yeah, so far as ADR is concerned, see, we have under section 22B, 22B of the Legal Service Authority Act, where we establish permanent Lok Adalat. In Meghalaya, we have notified in most of the districts. Now, these permanent Lok Adalats caters the disputes which involves public utility. when you talk about the challenges we face, you see, ADR is something which is relatively very new. We look at it from a very different perspective. In the sense, like you see, so far as the state of Meghalaya is concerned, see, the concept of mediation, the concept of conciliation, the concept of settling the matter is inherent in the local society. You look at the headman, you look at the darbar, all petty disputes which comes up in a locality or in a village, the first interference is with the local head. So now if these disputes, if the headmen and the local heads are trained to handle these disputes, lot of unnecessary litigation can be stopped. Now if we just look ADR to be imposed, or the method of resolving dispute to be imposed here, I think they find they'll take it quite some time to understand. But if we tell them that this concept is already there in the society, all that we need to do is that rediscover it and make it functional through the institutions of local head, a lot of petty problems can be resolved. So the challenge which we face is that now identifying, we are working out on that, and it's there in our mind that the local heads, they may be trained the technique, as I said, that when disputes of family comes, please keep it confidential, try to resolve it. And when you try to resolve, there is a mechanism. We provide training programs, all right, to the mediators. 40-hour training programs are there. How do you mediate? There is a technique. So it is a worked out, very well structured technique of resolving disputes. So now if we can cater the local heads and make people feel that it's nothing new which is there, which is already there, as you know that whenever some disputes arises, first confrontation is with the local heads. So that is one area. Now so far as the the challenges what we face is now, the biggest challenges, let me tell you that for past 2 years we are in this unprecedented pandemic. So now the challenge we face is that how do we communicate? How do we communicate? I may have good things to say, I may have good things to give, but then what are the means? We just cannot keep on sensitizing people without assessing whether this sensitization is really percolating, making difference in their life. So as a state legal, I understand, because I not only state legal, I believe all the institutions dealing with public at large, they are faced with a very unforeseen situation where everything is going virtual. Now we have rather we can say that the target groups is marginalized section. Now we can't expect the people who are at the periphery to communicate through mail, come through the video conferencing. So how do we reach them? You see, all is good, but until unless we don't deliver. So this is the biggest challenge we have. How do we reach them? As ma'am was speaking about the legal aid. Yes, legal aid, but how do we reach them? How do we help them? Because now we have been distanced. We have to the communication has, the mode of communication has changed. So very well that when we say the marginalized section, they may not have the sophisticated gadgets. They may not communicate with the court through VC. So these are the things, are biggest challenges we have, and these challenges which we are confronting now is not only challenges, it has undone the works which we have done for past how many years. It has pushed us back. We have tried to reach out to those people, we are making some headways, but then for past 2 years perhaps our work has slowed down and it has pushed us back. This is the biggest challenge. So I just feel that sensitization programs, reaching out to people, in implementing NALSA schemes, These are working in these conditions is a biggest challenge.
Yes, I think you've very rapidly said, especially with pandemic, what you've said, it's a biggest challenge. And accessibility, the most important is when we talk about legal service authorities, is for marginalized people or who cannot afford, even for simple mediation or awareness, which you all are doing. But it becomes very, very difficult for them, even if you want to work on it. So I think, that's one of the biggest challenges, what you've really said. I would like to hear from ma'am also.
Just to add to what sir said, I just agree with sir. This pandemic has really brought us into such a situation where we can't even meet with people. However, even amidst this pandemic, I would just like to applaud the activities conducted by our paralegal volunteers. Because DLSA, District Legal Services Authority, works through the legal aid councils, who are lawyers, and the paralegal volunteers. So the paralegal volunteers are basically, located in the villages. So whatever activity that we're doing right now is only through the paralegal volunteers, because we can't go and move from one place to another because we don't know how this pandemic would turn. So our paralegal volunteers in the field have really worked, and during the pandemic, just to share a few stories that as we've seen. When I was working in one of the station, it happened that there was a lady who is a stranded laborer who delivered a child and who could not even pay the hospital bills. That was the situation. So when the paralegal volunteers came to know about the situation, they informed us, and then we tried to assist this lady. So what has happened was that when we interacted with this lady, she told us a story. She works like in a very far-flung place. Just to go from the place where she was staying to the place where a vehicle could reach took her 20 minutes. So the husband and one of the brother carried this lady to that vehicle. So when they went to one of the health care centers, they said, she needs a better health care where she has to deliver, there should be a C-section right now. She can't deliver a natural delivery, and we don't have those means here. So she has to be taken to a bigger hospital. When she went to a bigger hospital, she didn't have any money, and she didn't know that she was be taken there. So she was taken by an ambulance. Luckily that, the hospital did not wait for her to pay the fees. They gave her all the prenatal care that was required and everything. But eventually what turned out was that when she stayed in that hospital, she didn't even have the money to buy food. It was the people staying in the same ward who was helping her. So when these matter came to us, we provided assistance, whatever assistance we could. So our paralegal volunteers even, they went and donated blood for her. So these are the few things that we've done. We've helped stranded laborers during the pandemic. Some where, they could not even arrange for any ration anymore. So when we come to learn of all these things, as a legal service institution, I can't give them the ration, but at least I can connect them with the department who can help them. So these are the few activities that the Legal Services Authority has been, doing even during this pandemic. We've not stopped working completely. There are a few things that we've done. But when it comes to legal awareness, as sir has rightly said, it's a little bit dicey right now. It's not that what we've done like 2 years back, where we would go to villages and then talk to them, and then we see the immediate response of the people there. And when you go to like these far-flung places and they tell you, oh, is it so? So you tell them, you have a right to claim maintenance if your husband is not maintaining you and your child. No, my husband just got, after he married me, after I had a child, he left me. But if I go to the court now, how do I engage a lawyer? I don't even have the money to buy food. Then, that is how we give them assistance. Okay, so you have a paralegal volunteer in your village. He'll help you with the, coming to the office of the DLSA. And we, from our side, we give them legal aid councils who give free legal service. They don't have even to pay a single rupee. So this is how we help the people. But yeah, this pandemic has shown us, a different side of the world, like, it's very difficult for people for us to reach out to the people, basically.
I think you very rightly said, and it's so encouraging, and we applaud you. And I'm sure our audience hearing today will be very, very thankful and applauding, because I think you all went beyond your call of duty. And I think this pandemic, how you've said and how Sir said, it makes us as an individual and as people who we are in our professional lives, reflect and regard more compassion towards people and going beyond duty of call. I think that what makes it more applaudable. And one thing, like how you have said, that there are times when, yes, people didn't know. And yes, one of the things we have seen, and for each one of us as a challenge is that, yes, when we talk about connectivity, especially now with social distancing and the pandemic cases rising, it's the second year on hold that we are going through this. I mean, who would have thought in ever that we would be ending up doing programs like that, where we have to talk about what are the effects and post effects of pandemic. And it is very reflective and refreshing to see that how the district authorities and your legal service authorities are going way beyond their duty call, making an effort and trying to reach in whatever way you have done. And sir, what you've rightly said, yes, the hard work which you have put in, it really, because it was not something we had anticipated. But having said that, before we wind up, we would also like to add that it makes us help and reflect, as I said, also come out with innovative ideas. And this is a good spectrum, making us realize that we need to be innovative in ways of how we can reach to our people. Yes, there will be challenges when it comes to connectivity, which you're saying, and it is very true. But we can think of innovative ways, and I think one of the ways where people at least can access is programs like this, because this is something at least even people who don't have to have basic connection or of cable TV, still they can access Doordarshan, and that this is one way of going about. And it was lovely having you all, but before I conclude, I would like your last words on each one of you.
Yeah.
Your afterthought. And
no, I just wanted to share that was prior to the pandemic. What is the role of the legal aid? The State Legal Service Authority. I was wondering that these basically we carry out administrative works. Why judges? Why judicial officers? And that was in the year 2015. We had visited Joy Jail. And that time judiciary was not separated. We saw a huge number of UTP from Clarihar in the jail. They were never produced in the jail. They were just locked up in jail. I went for an inspection and saw that. When I came back, I said, we can't believe that a person can be kept in jail without being produced, without trial and everything. It is berserk. We came back and then we took it up as a PIL. That was a PIL number 2. Since we started with the PIL, I'd like to end up with the PIL. State Legal Service Authority filed a PIL. And in that PIL, the order was passed by the court, directing to release all those people, all those under trial prisoners who were not produced. Now, under the Legal Service Authority Act, we have a provision for filing social interest litigation. It is similar to that of PIL. The State Legal Service Authority and the National Legal Service Authority itself can file social interest litigation if it involves the right of large section of people. One example I can tell you is that was filed by the National Legal Service Authority, and that is with regard to the recognition of the rights of a third gender. It was taken up by the National Legal Service Authority in Honorable Supreme Court. So then I realized is that State Legal Service Authority, District Legal Service Authority are headed by the judicial officers. Now when we find any infringement of right, or there are certain statutory obligations or the statutory authorities are not discharging their statutory power, it's not all about we are going to tell the authority, as ma'am has said, that we can connect them. But after connecting them, if we find that still they are unmoved, then of course we resort to what you said, that if large section of people are there, we resort to social interest litigation, and we have the State Legal Service Authority has done it. And we are also not oblivious of the fact that basically people want to live peacefully, and the system is such that to buy peace, it's not so easy. So that is why I think, as ma'am has said, that the paralegal volunteers, the legal aid council, and finally, it's not all about the paralegal volunteers, legal aid councils. It is also for the courts. Courts are the first counsel of the accused persons. So we have to be very clear, the courts, the concept of the legal aid. Legal aid is not to be demanded. It is duty, and that is why you find that, as ma'am has said, that was in the Ajmal Kasab's case, where the Honorable Supreme Court said that it is the duty of the court. It's the duty of the court. And then finally, see, to be very frank, anything, people become very suspicious. Anything which is free, perhaps they become very suspicious about the quality. We are working very hard to see that all the services, we keep on saying that free, it matches up with the quality. That's why, as the Member Secretary of the State Legal Service Authority, I add this word and I emphasize on this word. It is not free legal aid, free competent legal aid. Competency subtracted, it becomes empty formality.
I think that's the best, and unfortunately we are running short of time. So I think that's the best way of ending actually the whole conversation which we had. And I think it really highlights, sir, thank you so much for highlighting. I think that's a very poignant point. And though we are running short of time, because it's such a lovely topic, we can go on and perhaps have more sessions in our coming episodes, hopefully. And I hope our viewers had taken back, and it was something they can look forward to. And with that, it was something very, very informative for me too. And I hope everyone, all our viewers, I hope you all have taken back something, and something you can, your approach that you have in ADR. And before you go into court, now how to go about it. You can directly approach also the District Legal Service Authorities. So thank you for such a lovely and informative session, sir and ma'am. And thank you so much for being a part. We are glad to have you. Our viewers, thank you so much for joining us. With this, we end our session. Thank you so much.